हेलो बच्चों, वेलकम in this lecture. Today we will discuss about the Article 15, Class 4. This is the special provision for backward classes. Article 15.4 provides nothing in this article or in Class 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and the scheduled tribes. Clause 4 of Article 15 is an enable provision. It merely confers descriptions on the state to make special provisions. It does not impose any obligation on the state to take any action under it. Article 15 Clause 4 contains another exception of Article 15.1 and Article 15 Clause 2. This clause was added by the Constitution First Amendment Act 1951 as a sequel to the decision of 7 judges bench of Supreme Court in State of Madras versus Champakam Dorai Rajan. If we talk about the backward classes, then the expression backward classes is not defined in the Constitution. Article 340 of the Constitution, however, empowers the President to appoint a commission to investigate the conditions of socially and educationally backward classes within the territory of India. On receiving the report of the commission, the President may specify the classes to be considered backward. And scheduled tribe, the expression scheduled caste and scheduled tribes have been defined under clauses 24 and 25 respectively of Article 366. Article 366 is to be read with Article 341 and 342 for this purpose. In the case of Gulshan Prakash versus State of Haryana, it is observed by the Supreme Court that Article 15 Clause 4 is only an enabling provision. Article 15 is not an exception but only make a special application of the principle of reasonable classification. Article 15 Clause 4 does not make any mandatory provision for reservation, and the power to make reservation under Article 15 Clause 4 is discretionary and no writ can be issued to effect reservation. In the interpretation of the scope of Clause 4 of Article 15, the two issues have arisen before the courts. The first is that what shall be the basis to determine a class to be socially and educationally backward, and the second is that what can be the extent or quantum of the special provision authorized by this clause. In the case of M.R. Balaji versus State of Mysore, The Supreme Court held that backwardness under Class 4 of Article 15 must be both socially and educationally. The, in this case, the caste of a group of persons could not be the sole or even predominant basis to ascertain whether that class should be taken to be backward for the purpose of Article 15 Class 4. The court held that as regards social backwardness, the main determining factor would be the result of poverty. One's occupation and place of habitation could be the other relevant factor in determining social backwardness of a class of person. The court thus invalidated the test of social backwardness, which was based predominantly, if not solely, on the basis of caste. In P. Rajendran versus State of Madras, the Supreme Court upheld the test of backwardness, which was solely based on caste. The court observed that it must not be forgotten that a caste is also a class of citizens, and if the caste as a whole is socially and educationally backward, reservation can be made in favor of such a caste on the ground that it is socially and educationally backward class of citizens within the meaning of Article 15 Class 4. In Indra Sawhney versus Union of India, this case is known as Mandal Commission case also. Okay. In this case, the matter seems to have been settled by the majority of the Supreme Court, holding that caste can be an important or even sole factor in determining the social backwardness, and that poverty alone cannot be such a criteria. And in the case of National Legal Services Authorities versus Union of India, the division bench of the court strongly advised the government to gradually discard the caste centric definition of backward and evolve new practices, methods, and yardsticks to discover and address emerging forms of backwardness. It has recently been ruled that Hijras or transgenders are entitled to benefits as socially and educationally backward class of citizens. They are also held entitled to reservation in public employment. Granting the OBC status to the third gender, the Hijras or transgenders, this judgment has been held to be pathfinder and thus explaining the emerging forms of backwardness. In M.R. Balaji versus State of Mysore, the Supreme Court laid down that a special provision or reservation for weaker section of the society must not exceed 50% limit. It has been held that the principle of fixing the percentage of reservation emanates from the doctrine of reasonableness. In this case, the Mysore government issued an order reserving seats in the medical and engineering colleges in the state. Under this order, the reservation provided was as follow: backward classes 28%, more backward classes 20%, and scheduled caste and scheduled tribe 18%. Thus, 68% of the available seats in the colleges were reserved seats and only 32% seats were left for general merit pool. The Supreme Court thus laid down that special provisions or reservation for weaker section of the society must not exceed 50% limit. In Indira Sahni versus Union of India, the Supreme Court finally held that, barring any extraordinary situation, reservations should not exceed 50%. Now we have to see Article 15, Clause 5. The Constitutional 93rd Amendment Act 2005 has inserted a new Clause 5 in Article 15. The new clause enables the state to make by law special provisions for the advancement of any socially and educationally backward classes of citizens, or for the scheduled caste or the scheduled tribes. The important cases which are related from this Article 15 Clause 5 are mainly T.M. Mepai Foundation versus State of Karnataka. In this case, the 11-judge constitutional bench headed by Chief Justice held that state government cannot regulate the admission policy of unaided educational institutions by linguistic and religious minorities. This does not mean that state government cannot specify the academic qualification for students and frame rules and regulation for maintaining educational and academic standards. In Islamic Academy of Education versus State of Karnataka, the court held that the state can fix quota for admission to educational institution, but it cannot fix fee. The admission to these institutions can be on the basis of common interest, entrance and merit. In P.A. Inamdar versus State of Maharashtra, observing the education is national wealth essential for the nation's progress and prosperity, the Supreme Court held that right to establish an educational institution being an occupation is guaranteed to all citizens under Article 19(1)(g) and to minorities under Article 30. However, merely because Article 31 has been enacted, minority educational institutions do not become immune from the operation of regulatory measures. The right to administer does not mean the right to maladministration. So, to overcome the effect of above three decisions of the Supreme Court, Clause 5 was added to Article 15 of the Constitution by Constitution 93rd Amendment Act 2005, which lays down that nothing in Article 15 or Article 19(1)(g) shall prevent the state from making any special provision by law for the advancement of any social and economic backward classes of citizens or for the scheduled caste and scheduled tribes. Now, the provision of Article 15 Clause 5 relates to admission into educational institution, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions under Article 31 of the Constitution. In the case of Ashok Kumar Thakur versus Union of India, a constitutional bench of the Apex Court has upheld the validity of the 93rd Amendment Act 2005. and after it, the 103rd Constitution Amendment Act 2019. With the help of this amendment, the Article 15 Clause 6 is added in Article 15. There has been an amendment in Article 15. By the virtue of this article, Clause 6 is added in Article 15. Article 15 Clause 6 caters reservation to the economically weaker section of the upper caste, and the special provisions relate to their admissions to educational institutions, including private educational institutions, whether added or unaided by the state, other than the minority educational institutions referred to in Clause 1 of Article 30. This respective amendment aims to provide reservation to those who do not fall in Article 15 Clause 5 and 15 Clause 4, effectively scheduled caste, scheduled tribe, and other backward classes. Now, you have to learn these provisions with the help of your books and the bearer of the Constitution. Thank you.